Welcome back to another J. Harris Academy Police Training Roll Call. I'm Joey Sperlazza. Today we're going to be discussing a Miranda case. This is an appellate unpublished decision decided January 7th, 2025, State versus Ruffin. So we're going to explore two specific aspects of Miranda within this case. During the booking process, detectives were trying to fingerprint him, photograph him, ask him booking questions. This was not an interrogation. During that process, which was recorded and played at trial, the defendant gave some admissions. Those admissions were used against him. So the question was, should that have been subject to Miranda? And the answer is no. Booking questions, typical questions that we're asking people on their pedigree, their background, that is not subject to Miranda. So properly, those statements were not suppressed when they were played at trial. The second piece is during the actual custodial interview. At one point, the defendant said, well, I guess I want to talk to my lawyer then. At that point, you got to stop. We're done. That is a clear invocation of his Miranda rights, and anything that happened after that was properly suppressed at trial. So let's look at the actual appellate decision. Following a jury trial, the defendant was convicted of third-degree conspiracy to commit aggravated assault, attempting to cause significant bodily injury, 2C5-2 and 2C12-1B7. This appeal focuses on two post-arrest statements made by the defendant, the recorded booking statement and the recorded interview statement. The trial court found that the defendant made unsolicited and spontaneous statements during the booking process. While he was in custody, the trial court found that the defendant was not subject to an interrogation because detectives were not trying to question him, did not engage in the functional equivalent of questioning, and based on their body language, tried to ignore him. Accordingly, the defendant's voluntary statements were admissible, were not made during a custodial interrogation, and could be played to the jury. During the recorded interview statement, the trial court granted the state's motion in part, admitting that the defendant's statement and the video up to a point where the defendant stated, well, I want a lawyer then. The court reasoned that the defendant waived his Miranda rights and voluntarily gave a statement. The court also granted the defendant's motion in part, finding he made an unambiguous assertion to the right to counsel, which required the interview to cease, and therefore the defendant's statements and the remainder of the interview was suppressed. A redacted recording of the defendant's formal interview was played to the jury. On appeal, the defendant argues that his two statements following his arrest should have been suppressed. Their improper admission requires reversal of his conviction. The detective's questions exceeded the scope of the limited booking exception of Miranda. The defendant unambiguously invoked his right to counsel. The defendant's repeated references to contacting a lawyer should not have been played for the jury. The detectives improperly contradicted the Miranda warnings during the formal interrogation. The appellate court ruled on the booking statement. The defendant objected to the booking room video being played to the jury because he mentioned a lawyer 3 times during the booking process. The trial court overruled the defendant's objection, finding that the defendant's statements were voluntary, there was no interrogation, and the detectives were not required to stop and read defendant his Miranda rights when he referenced a lawyer. While sitting on the bench, waiting to be processed, the defendant started talking about the fight. The defendant asked why he was at the station and then stated, I've got a lawyer coming. I didn't do nothing, bro. To which the detective responded, that's fine. All right, that's fine. The defendant repeatedly interrupted, proclaimed his innocence, claimed that he diffused the situation, and offered his cooperation. In between and over the detective's booking explanation that the defendant would be fingerprinted, given his Miranda rights, and his statement would then be recorded. Again, the defendant responded, all right, and continued talking about the fight. The detective told the defendant, let's not talk now. The defendant continued to talk as he obtained his biographical information. The detective asked the defendant if he knew the victim's brother. He said he did. And then the detective also asked the defendant to listen to his instructions. The defendant then asked the detectives if he could call his girlfriend so he could get the number to call his lawyer or something, and stated he would be cooperative without being charged, but if not, then he better get a lawyer. Neither detective responded because they were focused on solving a technical problem with the photography software. The defendant continued to proclaim his innocence as he was fingerprinted, and the detective told him that a lot more evidence had come to light since his last interview 2 days earlier. The defendant called the evidence lies, repeated that he was innocent, and made more statements. The detectives made no further statements and did not ask the defendant any substantive questions. The defendant's contentions are not supported by the record. Throughout the booking process, the defendant made unsolicited and spontaneous statements, despite the detective's repeated instructions to the defendant that his Miranda's warnings would be given before a formal statement was taken. Neither detective's testimony nor the video show the defendant's statements were the result of a custodial interrogation. Accordingly, the defendant's voluntary statements fall within the booking exception. The detective's statement to the defendant that a lot more evidence had come to light was not tantamount to questioning or a functional equivalent that was particularly evocative or reasonably likely to elicit an incriminating response. The detective's question to the defendant whether he knew the victim's brother was not a targeted question to attempt to cause the defendant to incriminate himself. Under the totality of the circumstances, his booking statements were voluntary in every way that they possibly can be. The defendant next argues the booking statement should have been suppressed because he unambiguously invoked his right to counsel as shown in the booking video. The argument is not supported by the record. When a suspect indicates in any manner and at any stage of the process that he or she wishes to consult with an attorney before speaking, there can be no questioning. If a suspect makes an ambiguous assertion that is susceptible to different meanings, the interrogating officer must cease questioning and inquire of the suspect as to the correct interpretation. However, not every reference to a lawyer requires a halt to questioning. Each case is fact-sensitive, so a reviewing court must determine whether the mention of counsel constitutes an invocation of the right to counsel. The reviewing court should consider the totality of the circumstances, including all of the suspect's words and conduct. The defendant's statements were not a product of a custodial interrogation. The defendant's fleeting statements, whether a lawyer, this lawyer, and wanting to call this lawyer or something, were ambiguous and part of his voluntary stream of comments. Clarification was not required since this was not a custodial interrogation. Instead, the defendant continued to offer voluntary statements and did not expressly state that he wanted to speak with counsel. The court properly admitted the defendant's statements made during the booking video. The appellate court then ruled on the formal interview. After receiving his Miranda warnings, the defendant waived his rights and provided a video-recorded statement. The defendant then made 3 attempts to negotiate a deal with detectives. First, the defendant asked whether his charges would go away if he told him what they knew. The detective only told the defendant that he could not make any promises and stated the truth can only help your case. The defendant continued providing a statement while maintaining his innocence. Second, when asked who stabbed the victim, the defendant told the detectives, "Put it in writing that I get to leave today and just go free and I will be your witness." The detective restated that he could not make any promises but said cooperation gives you consideration. In his third and final effort, the defendant told the detectives that he would give the truth, it goes away, and he goes home. Case closed. The detective responded that it was impossible for him to offer the defendant leniency in exchange for a statement, and at that moment, the defendant said, "Well, I want a lawyer then." The detective nevertheless continued with his interview. The defendant unambiguously invoked his right to counsel when it became clear that the detectives were unable to negotiate a deal with him to go home. The trial court correctly suppressed and excised the defendant's statement that he wanted a lawyer, and the remainder of the interview, which was not played before the jury, the conviction was upheld. Though this is an unpublished opinion, it reaffirms everything we already know. Custody plus interrogation equals Miranda. The first part, during booking, that was not an interrogation. He was making spontaneous utterances. He chose to volunteer that information to the detective. Because of that, it was not a custodial interrogation, and all of those statements were properly admitted. For the second part, he was clearly in custody. It was clearly an interrogation. He was already advised of his Miranda rights. He was trying to negotiate a deal. During that negotiation, when he saw it was going nowhere, he specifically said, "Well, I guess I should talk to my lawyer then." That looks like, talks like, smells like lawyer. You gotta stop. Everything was properly suppressed after that, and luckily they had enough on this individual to be able to get a conviction on him. If you have more questions about this, check out our other videos on Teachable and YouTube. Come to one of our in-person Miranda or case law classes where we go over this topic extensively. Until next time, Joey Sperlazza, stay safe.
This podcast is brought to you by the J. Harris Academy of Police Training. J. Harris Academy of Police Training is based in New Jersey and provides law enforcement training services nationwide for promotional examinations, use of force, supervisory development, and other key areas within law enforcement. This podcast is utilized to discuss key topics occurring within the profession. The opinions and information provided is for entertainment purposes only. In an effort to provide this, we often purposely discuss opposite views and opinions to spark conversation and develop discussion points. The contents of the show and show notes are all copyrighted. All blog posts, podcasts, and show notes that are distributed to the public for free can be redistributed via hard copy or electronic copy for free only if the J. Harris Academy of Police Training is included as the acknowledged author within the actual media that is redistributed. This entire disclaimer also applies to any guests or contributors to the podcast or blog. Under no circumstances shall the J. Harris Academy of Police Training, any guests, contributors to the podcast or blog, or any employees, associates, or affiliates of the company be responsible for damages arising from the use of the information provided.